You've just finished answering all the questions in your pretrial deposition in a medical malpractice case. And privately, you turn to me and say, how did you know that he was going to ask all these questions? Would you like to know the answer? Come join me for a walk on this deserted island as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, I have a few minutes to share this great information with you while my wife is out picking seashells on this totally deserted island. How was it that I was able to know exactly what questions the defense attorney would ask? Well, number one, preparation. It is critically important that before you answer questions from the defense lawyer during this pretrial question and answer session known as a deposition, lawyers also call it an examination before trial. It is critically important to know what topics he's going to be talking about. It's critically important to know what subject areas he's going to be asking you questions about. Not only will you be asked questions about your history, your medical history, your family history, he's going to ask you questions about the events that led up to this particular claim, as well as the events that actually occurred, as well as what occurred afterwards. And then he'll go into what we call damages, learning about the injuries that you suffered as a result of whatever his client did or did not do. And importantly, he's also going to ask you many, many questions about how your injuries have affected you and your family on a daily basis. Before you ever get to appear in front of the defense attorney to answer his questions during this deposition, you will have to be prepared by your attorney. I will have to sit down with you, or by phone, or by Zoom call, and go through with you the exact types of questions that he's going to ask you. Now, I don't need to see a handout of exactly what script he's going to use or exactly what questions he's going to use to ask you what happened. I know exactly what he's going to use and what he's going to ask. Why? Because I've been doing this now almost 34 years. I started out my career as a defense lawyer asking injured patients, injured victims, these exact questions. And it has to do with your history, your physical history, your medical history, your family history, right? And it has to do with your background, your schooling, your education. Where did you go to school? What's your highest level of schooling? And your work. What type of work did you do? Where did you work? For how long? What were your job duties? How much did you earn? These types of questions are critically important to understand who you are and where you come from. Then he'll get into the details of your particular case. Now, there will be instances where the defense attorney will be asking you questions that you know in your mind have nothing whatsoever to do with the claims that you are bringing or with the doctor's defenses. In that instance, you might be wondering why you actually have to go ahead and answer those questions. The reality is that this is the discovery process. The defense is given a lot of latitude to try and ask questions about who you are and what occurred to you. And because of that, many times the defense is permitted to ask questions that we believe are not related to the key issues in this case. However, it does not necessarily mean that they will be able to use that information if and when your case goes to trial. But for the discovery phase of your case, more likely than not, the defense attorney will be able to ask questions that you perceive to be unrelated to your particular claims. So, how do we know what types of questions you're going to be asked? It's because an experienced attorney is going to know it, because this is the type of questioning that goes on every single day in these cases. These are the questions that we will ask you at the time of trial during direct examination. Now, what does that mean? When we get to trial, we have to have you on the witness stand, and now we will ask you questions that will familiarize the jury with who you are, where you're from, what type of person you are, and things of that nature. So the defense is trying to learn this information before we ever get to trial. So in all likelihood, by the time you are done being questioned by the opposing lawyer, in all likelihood, you will have been fully prepared and know exactly what types of questions the attorney is going to ask you about, as well as the topics that the lawyer is going to ask you about. And that's because this is what we do on a daily basis. This is what we do every single day. By the time you are done answering the defense attorney's questions, you will know exactly what topic he's going to ask you about. You will know exactly what questions he's going to ask you about. Now, one of the things that we always prepare you for is to answer the question about whether you have ever been convicted of a crime. That is a critical question that the defense will ask you about, and it goes to credibility. The other question that also you will be asked is, have you ever declared bankruptcy? And there's a very specific legal reason why the defense needs an answer to that question. So, When you are asked that question during the course of your deposition, you are likely going to think in the back of your mind, wait a second, Gerry already told me that he'd be asking me this question. And yes, that's true. I did tell you, and guess what? Now the defense attorney is asking you that exact question. There are some people who think that preparing for a deposition means that the attorney provides the injured patient, provides the injured client with an answer. And that would be 100% untrue. That would be 100% incorrect. Instead, what we are doing is simply exposing you to what questions are likely going to be asked, so you have an opportunity to think about the answer and to recall what you believe the answer to be. This deposition process is really a memory test. And even though there's no bonuses for getting things right or wrong, the fact is it's designed to test your memory. What do you remember about this conversation that you had with the doctor? Tell me about what happened next. What do you remember after that? Who did you see next? When did you see the doctor next? And so this is designed to try and trigger your memory so that now when you are asked the question during your deposition, now your memory will have been refreshed. Now you say, wait a second, I do remember it now. And now you can go ahead and give the answer. So why do I share this quick information with you? I share it with you just to give you an understanding of exactly what happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I recognize you're likely watching this because you wanted to see the rock formations and the beautiful scenery. No, I realize you're watching this because you likely have questions or concerns about your matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.